Good afternoon, everyone. The Appellate Division, First Department, is now in session. As a first order of business, I'm going to be calling the calendar. When you hear your case called, please respond as being present with your name, and then I will confirm to you the time that's been allotted for your argument. Start with the first case, People versus Miguel Diaz. That is submitted. Geico versus Hernandez.
Heather Harlem-Beatties, present on behalf of Geico Appellant.
Respondent Countrywide.
And the time allotted is 5 and 2 for the appellant and 5 for the respondent. Stephanie E. versus Afrain G.
Bruce Young for the respondent. Good afternoon.
Good afternoon. And Mr. Young, you will have 3 minutes. WMOP LLC versus Scottsdale Insurance.
Joseph D'Ambrosio for defendant appellant Mount Hawley. Good afternoon, Your Honor.
Good afternoon.
David Ham for the plaintiff and respondent and appellant, WMOP.
Good afternoon, Your Honor. Courtney Scott for defendant cross respondent Scottsdale Insurance.
Right. And I've allotted 4 and 2 to Mr. D'Ambrosio for Mount Hawley. Mr. Ham, you have 4 to oppose Mount Hawley's appeal, and then on your own appeal, you'll have 4 and 2, and Ms. Scott, you'll have 4. And I think basically we're going to structure this so that we'll hear the Mount Hawley appeal first, the 4 and 2, and then we'll hear the plaintiff's appeal for 4 and 2.
Thank you, Your Honor.
Thank you, Your Honor.
Alachia versus Mundy.
Good afternoon, Your Honor. Jeremy Barberi on behalf of the appellant.
And Jameson Davies on behalf of the respondents.
Good afternoon. You each have 5 minutes.
Thank you.
People versus
Thank you.
Charles Little.
Good afternoon, Your Honor. Mandy Jaramillo with the Office of the Appellate Defender for the appellant Charles Little.
And good afternoon, David Slott on behalf of respondent, the Bronx District Attorney's Office.
And the time allotted for the appeal is 8 and 2 for the defendant and 8 for the people.
Thank you, Your Honor.
Thank you.
Excuse me. The next case is Vitkina versus Benalawal.
Good afternoon, Your Honor. Martin Karlinski on behalf of appellant Vitkina.
Brian Isaac for the respondent.
And you're each allowed 5 minutes on the appeal.
Thank you, Your Honor.
Thank you, Your Honor.
Bamberg Taylor versus Strouch.
Peter Paretsky on behalf of the appellant.
Judy Shaughnessy for the respondents, Your Honor.
And you're each allotted 3 minutes. Ed Shaw Tagui, and I'm sorry for the pronunciation, versus the City of New York.
Good afternoon, Your Honor. Chris Della Carpini for the appellants.
Right, and how do you pronounce your client's name?
Enchitegi.
Enchitegi, boy, was I off. Thank you.
Good afternoon, Your Honor. Kate Fletcher for the City of New York.
Thank you. And the time allotted for the argument is 5 and 2 for the appellant, 5 for the respondent.
Thank you.
Thank you.
People versus Sanchez is submitted. McCants versus Franchi is submitted. Simon versus Frank Invest. There are 2 cases.
Good afternoon, Your Honor. William Siegel for the defendants, respondents, George Kessler and Lynn Rosenberg.
Right, and you're the only one who requested argument time, and I gave you 8 minutes on these complicated appeals.
That is correct. Thank you, Your Honor.
Okay. Salish Large versus Gift Management is submitted, and Dennis versus 44th Enterprises is submitted. The first case on the calendar is Geico versus Hernandez.
Good afternoon. Can everyone hear me?
We can.
Okay, good. May it please the court, my name is Heather Harlambides, and I represent the petitioner appellant Government Employees Insurance Company, which I will refer to as GEICO. In this case, respondent Henry Hernandez has made a claim for uninsured motorist benefits against his GEICO policy. In response to that, GEICO has brought a petition to state arbitration based on the fact that the vehicle that struck Mr. Hernandez was identified and insured by Countrywide Insurance. The only opposition received to the petition was by Countrywide Insurance, which submitted an attorney affirmation that was 5 paragraphs long. The lower court held that the petitioner GEICO had met its burden to justify the stay of the petition. However, the lower court went on to find material issues of fact based upon Countrywide's argument that the adverse vehicle identification in the police report was vague.
Well, excuse me, this is Judge Mazzarelli. Wasn't there a letter that indicated that the insured of that vehicle, Mr. Soto, said that he had had no involvement with the accident, denying any knowledge or involvement in it?
There wasn't a letter. There was a claim, a denial of claim for no fault insurance benefits that just had a indication at the bottom of the form that the insured denied involvement. It wasn't an official letter by a claims representative giving forth the investigation or the denial of claim.
Well, why doesn't that document, shall we call it, suffice to raise an issue of fact which needs to be resolved in a framed issue hearing? That's all that's been ordered here is a framed issue hearing.
I understand that. The reason why this particular document is insufficient is it's not a proper denial of claim form. It doesn't give the specifics as to the grounds which the disclaimer is predicated on, and is just a general denial of claim for no fault claim benefits. In this case, the lower court found that the petitioner did meet its initial burden of proof as to staying this arbitration based upon there being an identified vehicle in this case.
So, counsel, if I may, I also find it peculiar that an attorney's letter is sufficient, or an insurance letter is sufficient to create a framed hearing issue simply by saying, my insured says I had no involvement. But I looked at 2 cases and I'd like you to comment on them, if you would. One is AIU versus Cabreja, First Department, 2003. And the other one is Allstate versus Rivera. And they both say that an attorney's affirmation isn't enough to establish lack of coverage, but it is enough to warrant a stay pending a hearing to determine coverage, and the court would determine coverage. So what do you have to say to that?
Well, in the AIU case, it was different than the one in this case. There was a letter by GEICO that was submitted that gave the grounds of the denial of claim. And there was conflicting information in that petition as to whether or not the vehicle was properly identified. In this case, there isn't conflicting. I would say that there is not conflicting grounds because there was no such letter presented, just a denial of claim form that had some sort of reference to their insured denying involvement in this accident. An attorney affirmation has never been alone sufficient to defeat or rebut a prima facie showing. In this case, there was nothing more than Countrywide trying to point to possible gaps in the petition. In the case law cited by the respondent, those cases had more than just an attorney affirmation to create an issue of fact, such as Government Employees versus Escato. An affidavit was submitted in opposition by a claims representative, their insured, and a physical damage appraiser. In matter of Hertz versus Holmes, an affidavit was submitted in opposition of non-involvement by their insured. in Progressive versus Bartner, affidavits by the respondents who were involved in the accident were submitted to create an issue of fact. An attorney affirmation is of no probative value, and is this court First Department's controlling principles that it's patently insufficient to just submit a attorney affirmation to try to possibly poke holes at a petition that to stay arbitration when the petitioner has met their burden of proof.
Your time has run out, so I'll give you time on rebuttal. Let's hear from your adversary.
Good afternoon. May it please the court. My name is Thomas Tordo, and I represent Countrywide. It's our position that the Supreme Court properly ordered a framed issue hearing based on questions of fact that were raised by Geico's own petition. Next to Geico's petition.
Mr. Tordo, you would allow that an attorney affirmation cannot create the issue of fact.
Yes, I agree.
Okay, so what are the issues of fact here and what creates them?
Geico's own papers have annexed to it. Number one, Countrywide's denial of claim, which is based on the ground that their investigation revealed that their insured had no involvement in the suit. Now, ordinarily, an attorney's affirmation would be insufficient, but since Geico has chosen to present that document in the first instance, it can be considered as evidence that the Countrywide's insured was not involved in the accident.
So in other words, if it was attached to the affirmation, we wouldn't be able to look at it.
That's right. And additionally, and you have that a lot with the threshold litigation where the defendant movement annexes unsworn reports of the plaintiff's doctors on the first instance, and the plaintiff can rely on those unsworn reports and oppose it in the motion. The same principle should apply here. Additionally, at page 70 of the record is the so-called verification of crime report, and that contains two different license plate numbers, FPY 3291, and another point in the report is a license plate number of FRY or FPY 3291. So it's our position that based on the very papers annexed to Geico's petition, the verification of the crime report, and the Countrywide denial of claim, that there's a sufficient factual issue as to whether or not there was an involvement of Countrywide's insured in the accident, and therefore the Supreme Court properly ordered a framed issue hearing, which, by the way, the absence of involvement in the accident would constitute a proper ground to for uninsured motorist benefits to be awarded to Respondent Hernandez. So, unless the court has any questions, I'll rely on the cases cited in my brief.
Any questions, colleagues? Okay, Ms. Haralambidis, we'll hear from you again.
I would like to address the issue of the police report, if that's all right with you. Geico
would like that. Go ahead.
Geico did not rely upon this police report to identify the vehicle that left the scene of the accident. Henry Hernandez called Geico the day of the accident and identified the vehicle and gave a description directly to Geico, reporting the license plate number to them. Based upon this information, they did a DMV search within the scope of their normal business practice, which came up with a vehicle matching the plate number and the description of the vehicle. And it was identified as Felix Soto's vehicle insured by Countrywide. The police report corroborates that information and gives that detailed description, the red Nissan, the year, the plate number, and the VIN number. Yes, there is one letter off in the body of the bottom of that police report, but based upon his information given directly to Geico and not in this police report, that vehicle was identified. The police report corroborates that correct information, and a DMV report is sufficient for prima facie showing of insurance coverage. So it's our contention that there is no conflicting evidence whatsoever in Geico's petition to stay arbitration. The way the vehicle was identified was through respondent Henry Hernandez directly. The denial of claim form is a form letter not written out that gives a specific denial of claim. So I would contend that it is not sufficient to create an issue of fact.
Okay, thank you. Thank you both.
Thank you.
Very much, Your Honor.
Okay, the next case is Stephanie E. versus Ephraim. Mr. Young?
May it please the court, Bruce Young for the respondent, Stephanie E. Thank you for the opportunity to see and be seen here today. Perhaps not even essential. I don't have an appellant I'm arguing against. However, that was somewhat the issue that arises in the case. An urgent matter of family offense, obtaining an order of protection from a person who was threatened physically, verbally, and there was a pattern of it. In the past, before the COVID days, she would leave when this person got into their disturbance and go to her mother's house or something, which she wasn't able to do in the COVID. So she came to court, and the court had to address it. They found it so urgent that an ex parte order removed him from the house. And then really the core of a prompt hearing, a prompt post-deprivation hearing after he was removed from the apartment, required that he was the one needing a prompt hearing. He was out. He chose at the hearing to not make it a he said, she said. He said, I deny the allegations. He did not give his version of what happened. So it wasn't that difficult for the trial judge to make a credibility determination, which they acknowledged was limited. They didn't have video. They only had audio at that time in July, when the hearing was held 2 weeks after the incident, after he was removed. So he never really put
the respondent was represented by counsel, wasn't he, during that hearing? Yeah. And did counsel object to the use of telephonic means for the hearing?
I believe that they did object to it, but over objection, the court said, I can't force them to come to court. It wasn't an opportunity. And the requirement for a prompt hearing required that. So the hearing went forward, and by audio, the judge acknowledged that.
Counsel, I'm sorry. I need a clarification.
Sure.
What date are you speaking about? Because the hearing took place in July. On July 1st, both parties appeared with counsel virtually. Counsel was able to be seen. Both parties were unable to be seen, but they testified telephonically. Am I right?
That's correct.
Are we talking about the same hearing?
Yes, that was the hearing. The hearing, they appeared telephonically.
So if counsel didn't object and both parties appeared telephonically, not one side virtually with the video in place, but the other side with the other side telephonically, but both sides testified by phone, where do you see the problem? There was no objection, and the judge took great pains to ascertain that the proceeding was fair.
I don't see a problem. I see that a prompt hearing was granted because he was out and he's the one who needed the hearing. I'm on behalf of the respondent and on the appeal. I think there was an adequate hearing under these exigent circumstances. We're all improving now. I can see you today. Last week I couldn't get my camera to work, so we're all in a new world and a new illness and a new way that technology and law is addressing these issues.
But Mr. Young, this is Judge Mazzarelli.
Hi, Judge.
Hi. For many, many years, we've been doing neglect, parental termination rights hearings, abuse hearings with incarcerated defendants appearing either telephonically, or I don't think any of them have appeared virtually, as we call it now. We have not found anything objectionable about that procedure, and I think in certain of those proceedings, the standard of proof here is a fair preponderance of the evidence, and in certain of those proceedings, the standard of proof is higher.
Correct.
So if that has been, the case law that has governed in those kinds of proceedings, why would that not apply in this type of proceeding?
I think it does apply, and there's a long history of it, as well as the current circumstances that do permit it. The way I try to analyze it is the nature of the rights at stake and how urgent is the necessity for a post-deprivation hearing under due process. And here, there was a need for a prompt hearing. Otherwise, you'll wait till next year. I mean, except he's out of the apartment, so it makes sense to hold a prompt hearing. The judge acknowledged the limitations, but he said in the tone and the quality of the voice, not to mention that there were no actual factual disputes of what happened, just I deny it. So it didn't make it too difficult to make a credibility determination, which is the core thing that he's arguing about.
Any further questions, colleagues?
Thank you very much.
Thank you. WMOP versus Scottsdale Insurance.
Good afternoon, Your Honors. Joseph D'Ambrosio for the defendant appellant Mount Holly. Our core argument on this appeal is that the trial court applied the wrong standard to the prior notice exclusion. The court applied a subjective knowledge standard when we submit that it was an objective standard that should have applied. There are two different exclusions that come up in these cases, Your Honor, what are commonly known as prior knowledge exclusions and then prior notice exclusions. We specifically recognize that subjective knowledge would be relevant to the prior knowledge exclusion. So we limited our 3211 motion to the prior notice exclusion, which only requires the court to determine whether in fact prior notice was given. And under this exclusion, Your Honors, it is very, very broad. It is as broadly written as you can write it. It excludes coverage for any claim arising out of, related to, directly or indirectly, or in any way involving any, and we focused on the language fact, matter, or event that was notified or reported to a prior policy of insurance. There's no dispute here that the insured gave notice to Scottsdale, the prior insurer, of the Eisner matter. Now, we don't need to guess whether it related in some way. We know for a fact that it's the identical matter. It's the same matter. It's the same it's the same deceased resident, same medical treatment and care at the facility, represented by the same premier upstate New York personal injury law firm.
Counsel,
yes.
Counsel, this is Judge Mendez. So you're saying that first letter that they sent to Scottsdale, wherein they referred to the need to preserve medical records that was accompanied by a HIPAA form, that constituted sufficient notice under the prior acts exclusion of your policy?
Under the prior notice exclusion, that's exactly right, Your Honor. We're saying that our exclusion, which may not be the same as other exclusions, it is written so broadly that yes, that notice that was provided to Scottsdale that included the letter from that same personal injury law firm attaching a HIPAA compliant authorization saying maintain the records for purposes of litigation and trial, accompanied by a notice of occurrence, satisfies the very broad language in our exclusion. That is our position. And we respectfully submit, Your Honors, that the wrong standard is confirmed by the cases that the trial court cited against us. Those are the Ulster versus CSI, CPA Mutual from this court, Executive Risk Management from the Court of Appeals. You look at those cases on their face, they are all prior knowledge exclusion cases. This court, on the other hand, and we have cited these cases, particularly in the Berkshire Hathaway case from just a few years ago, enforced a prior notice exclusion and just looked to see, was notice given? A very objective question that could be resolved here. There's no dispute that notice was given, so we don't have to determine, as the trial court said, whether a notice should have been given. Why do we have to address whether notice should have been given if we know notice was given? Again, that's why we only moved on that portion of the prior notice exclusion. There are other arguments that we have to deny coverage that we recognize would be premature, that would require us to determine the subjective knowledge of the insured. We did not move on those grounds.
Counsel, can you address the point that there was no actual litigation commenced, and can you go to that, because there's a lot of questions there.
Okay, absolutely, Your Honor. So that was the second main issue in the case, is whether the notice that was provided to Scottsdale had enough particulars as to the nature of the negligence. Okay, see, our position, that's imputing into our exclusion requirements of that are not there. You know, our exclusion is written so broadly that it doesn't need, that the notice given to the prior carrier doesn't need to have those details. You know, this language is written broadly to eliminate that question. It was used to eliminate that question, to make it so broad that when these issues come up as to whether there was sufficient notice to qualify as a claim or an occurrence or a medical incident, well, we don't want to deal with that. So we're going to include broad language so that those questions never come up. And, you know, it's ironic that that's the issue that we're now dealing with. We're trying to avoid that by including this broad language and not being tied to whether it fits the definition of an occurrence or a claim. We want to broaden it. We want to exclude coverage for anything that has some connection with something that was reported to a prior carrier. And here, unlike other cases, we don't have to guess and see if it was connected enough or close enough. There's no dispute. It's the same exact thing. It's the same. It's exactly the same. I don't think there's any question about that. And
Mr. Ambrosio, your time is up. We'll hear from you on rebuttal. Let's hear from Mr. Ham.
Thank you. My name is David Ham. I'm with Hertzfeld and Rubin, and I'm here on behalf of WMOP Achieve, the respondent to the Mount Hawley appeal. Now, Your Honor, the key issue is whether Mount Hawley demonstrated unmistakably that we violated the exclusion identified as a prior claims or occurrence exclusion, that's C2 of their policy on page 343 of the record. The key here is the language that was used in that provision, and whether or not the notice, the information that we provided to Scottsdale falls within that listing. We start off with any acts, errors, omissions. None of those were actually stated in the correspondence which was presented to Scottsdale. There were no acts, there were no errors, there were omissions. We weren't told about that by Finkelstein and Partners. There were no medical incidents identified. There were no occurrences identified. There were no suits identified, and there were no demands made in that letter. Demands, in this instance, meaning demands for money. None of that was presented in the information request presented to us by Finkelstein.
Counsel, didn't the letter make reference to a possible legal proceeding?
It stated the words legal proceeding.
Exactly.
And,
it referred to an incident that occurred at your facility at a given date, right?
No, Your Honor, I don't believe it mentioned an event, any activity like that on a given date. It identified when he was there, I believe, and that's about it. I can get it right in front of me.
Counsel, there was a HIPAA authorization, and
yes,
it said the reason for the request for the release of information was legal proceeding. And as to the date when the authorization would expire, it did say at the conclusion of the case or trial. So how does that weigh into what you're saying?
Well, there was no reference to any suit that was made, and there was no reference to any demands for money damages in that. There was a recitation that legal proceedings were apparently being considered. But beyond that, it doesn't fit into the language which is set forth in C2. I mean, the key, I think, now, which astute counsel for Mount Hawley is relying on, is the wording facts, matters, and events, which counsel believes to be so clear and obvious that it needs no definition. But in fact, facts and matters are ambiguous. The language, the events is ambiguous. And ambiguity, I believe, is identified by words that have more than one meaning. It can have two meanings. And by my count in my dictionary, matters has 24 meanings, facts has 8 meanings, and so does events. So it really depends on context. What does it mean, facts, matters, and events? That's why we posit that the concept of nostratura associis makes clear that that has to be fit into the other words in that group. So it has to be something which relates specifically to a medical incident or an occurrence or an omission or an error. And none of those was set forth in the information provided to us by the Finkelstein firm.
So I'm going to ask you, counsel, to explain something to me, and maybe I'm making too much of this. But given the fact that I believe the autopsy, the ME results, talked about, was it the ME results or was it the reason for death was attributed to malnutrition and bed sores and all manner of serious medical conditions. Didn't you fall into this automatically? Wouldn't that be an act, an error, an omission, or a medical incident?
Let me make this absolutely clear, Judge. That information was recited in a letter issued by Mount Hawley's claims examiner based upon a supposed investigation undertaken by Mount Hawley with not the slightest basis in any evidence. It was thrown in to that letter, which was disclaiming coverage, and there is nothing in this record which supports it. It has no business having been referred to in my adversary's brief because it is pure third generation hearsay, and it certainly is no basis for any kind of determination.
So there was no determination. Let me be a little more specific. There's no medical record that the patient was transported to a hospital where he was diagnosed with malnutrition, pressure sores, sepsis, and aspiration pneumonia. That's made up by Mount Hawley.
As a matter of fact, Your Honor, not even plaintiff in the complaint asserts all of those items. Doesn't mention sepsis, doesn't mention aspiration pneumonia. It does mention pneumonia. Unfortunately, it's always unfortunate when someone passes away. As I get closer to 86, I begin to be thankful for I begin to be thankful for all of the things which medical practitioners can do to keep us alive. But people do die in nursing homes, and people die when they go from nursing homes to hospitals without any connection to any kind of claim that can be made against the nursing home. So the fact that that Mr. Eisner passed away is most unfortunate, but there is nothing of evidentiary nature in this record, nor should there be, as to
right, and I just want to make that point before we move on so that we can hear from your adversary on rebuttal. But what we're looking at really is whether the policy includes coverage or excludes coverage. And actually that information, which may or may not have been in the medical records, doesn't affect whether notice was given in connection with this, correct?
Absolutely correct, Your Honor.
Okay, all right, let's hear from Mr. Ambrosio.
Thank you, Your Honor. The first thing I wanted to address, Your Honor, was this argument about ambiguity in terms of fact, matter, and event. I just want to point out for the court, in the Berkshire Hathaway case that we rely upon from this court 2 years ago, the language there was fact, circumstance, or situation. We respectfully submit that there, and the court there found that the language was unambiguous. So we respect.
I would only say to that relying on the dictionary to otherwise say that a contract is ambiguous is not normally what we do. Multiple definitions in a dictionary doesn't create ambiguity in contracts per se.
Right. And my further point on that, Your Honor, is that the way they want this to be read would be reading out of the exclusion entirely those words, fact, matter, and event, because he's trying to make them synonymous with the defined terms, the narrower terms, and that violates a canon of construction that we give effect to all words, we don't render words superfluous. And then the other thing is, Your Honor, tellingly, there was never any suggestion into the court below, any argument that this was ambiguous or that they couldn't understand what it meant. The bottom line is the language is broad. It was written broadly, purposely, to avoid this very situation as to whether or not some notice was sufficient to qualify as a claim under any policy. And then, this whole idea of claims made coverage, Your Honor, the main argument they had was that it was a catch-22, but this court has cautioned that for claims made coverage like this, you look at the policy language, and you're not guaranteed to have coverage under one or the other because they have different policies, different requirements. You can give notice to one that's not sufficient for that first one, but by giving that notice, there's no coverage under the second one, and that's just what happened here. And unless there's any further questions, I'll rest on our papers.
Any further questions, colleagues? Mr. Ham, on the Scottsdale insurance issues?
I thank you, Your Honor. With respect to Scottsdale, I think I'd prefer, if I may, to point initially at a document which I think was not given adequate notice by the court below, or for that matter by Scottsdale, and that is the loss run, which appears at pages 275 to 278 of the record, 279 of the record. This was a loss run which was created by Nationwide E&S, which is on behalf of Scottsdale. Nationwide is the Scottsdale parent. And it specifically says it is for Scottsdale, and it specifically recites our client. It recites that there is one claim, and it recites that claim is Eisner, Melvin Eisner, attorney record request. Now, what is the purpose of my reciting to that? As I do not suggest that was a notice of claim when they posted it, but it does, I think, manifest that a claim of some sort was received and acknowledged as same by Scottsdale, some form of claim, because they put it right into their record. Now, the case cited below as the basis for saying that we don't look at loss runs, it's totally off the mark, because that case dealt with a loss run submitted by the insured to the insurer, which listed 100 or 200 cases, and one of them happened to be the one which they had never notified the insurer about before. Said the court, no, we're not going to accept that as a notice of claim because you included it in this long list of claims. But here is a loss run which is created by the insurer having received the notice of some sort of claim. So what kind of notice of claim did it receive? Do we satisfy the notice of claim requirements under Scottsdale's policy? No, we don't. Notice of claim, the way it's defined and the way notice of claim is set out We did not, the information they presented did not include a demand for money damages. We recognize that, and it does not quite measure up to notice of claim. Now, when it comes to notice of incident.
So counsel, are you saying that there was no coverage under Scottsdale? The
No.
Scottsdale, see?
Not saying that at all, Your Honor. I'm saying we may not have satisfied the notice of claim provision, which is which appears on page 79 as A, paragraph A, under the first named insured reporting obligations. That's their obligation to show a notice of claim.
So
However,
you're relying on the notice of incident provisions that relate back.
In part.
Now, did you comply with the notice of incident provisions?
We say yes, and we say so because the notice of incident, unlike notice of claim, which is stated to be a condition precedent, notice of incident is not so stated, and therefore it falls into the Greenberg formulation, which this court had in the Greenberg case said in our case, which in our brief, which says notice requirements are to be liberally construed in favor of the insured, with substantial rather than strict compliance being acceptable. So we believe we did make substantial.
So what were you supposed to do, and why was it substantially compliant?
Okay.
What was the substantial
First thing we were supposed to show is how and when the incident took place. How, when, and where the incident took place. We know where the incident took place, and we said so. That was in the nursing home. The name and address of any injured person or witnesses. Well, Mr. Eisner was the injured person. There were no witnesses that we know of. We couldn't produce what we don't have. The nature and location of any injury or damage, well, that was in the nursing home. The circumstance by which you first became aware of the possible claim, well, that was the notice we received from the Finkelstein firm, which was known to
retain records, right?
Sorry?
To retain records. Right, that was a notice.
As was mentioned before,
right.
The statement that there was a legal proceeding, and the statement that there was, and the statement that there was.
As you phrased it in the Mount Hawley argument, that there was the potential for a legal proceeding, right?
Yes, and that's correct.
Right.
There's a potential, and that is what a notice of incident is all about. The potential for a legal proceeding. That is what it's about.
Does it matter at all that the record seems to indicate that people from Scottsdale, they've reached out to your client and they said, give us more information, tell us about this, and they just didn't receive anything more.
Let me address that.
A little bit of digging, couldn't you have found something out about what was going on here? And wasn't that your obligation to do in terms of providing a notice of incident?
Let me respond to that immediately. First of all, the statement that there was a phone call made, that is not something that should be a focus on a motion to dismiss under 3211. That's not the kind of evidence that you put in. But beyond that, the statement in the letter of, I believe it was June 5, which said, if you want to send us more, we'll consider it as a new matter. That statement doesn't help us in the least, because there is a requirement that we produce whatever we produce for the notice of incident before the expiration of the policy. The policy expired May 31. So by the time we got the notice that said, oh, why don't you send us more information, it wouldn't have helped us any. That was just a very nice way of saying go away.
Maybe that would have related back. All right. But your time is up, so let's hear from Ms. Scott for Scottsdale.
Apologies, I had some unmuting issues.
Yeah.
Good afternoon, Your Honor.
Taken. Yeah.
I'll open with the lost run because Mr. Ham addressed it. From Scottsdale's perspective, the lost run is a red herring. It has no bearing on whether Scottsdale considered the submission to be a claim. He's admitted that what was submitted, the accord form saying allegations unknown, attorney records request, is not a claim. So it's contradictory to say that the lost run recognized that it was a claim. All the lost run does is list matters that were reported. All it states is Melvin Eisner attorney records request. It shows that it was received and it shows that it was closed and no reserves were against it. The listing on a lost run, which typically is just a record of everything that came in, does not reflect, affect, or contradict Scottsdale's coverage position as set forth in our papers and Scottsdale's letter that the material received did not constitute a claim and did not comply with the unambiguous requirements of the notice of incident provision. Moving on, I think some of the court's questions have put a focus on the argument. The fact of the matter is, the notice of incident provision in the Scottsdale policy is absolutely a condition precedent to coverage. Counsel makes an issue of the fact that the first part of the provision speaking to reporting of a claim expressly includes the word condition precedent. The fact of the matter is, inclusion of those words in the notice of incident provision is not necessary for that provision to be a condition precedent under general contract principles. New York law is absolutely clear and well settled that compliance with notice provisions of a liability policy are a condition precedent to coverage. It derives from the basic concept that a condition precedent is simply an act or an event that must occur before the duty of a promise arises. It is not necessary that the policy include those two words for compliance with that provision to be a condition precedent to coverage. The simple fact is, the day before the policy expired, Scottsdale was sent a records request form.
Ms. Scott, this is Judge Gish. I just want to ask you, so is it your position that the requirement of a notice of incident is a separate condition precedent from a notice of claim? You have to fulfill both?
Well, no, you do not have to fulfill both.
You have to fulfill the notice of claim no matter what.
It's a claims-made policy, and as the court is well aware, the essence of a claims-made policy is notice to the carrier within the policy period. If there is a claim, which here there was not, notice must be provided. The only way an insured, such as WMOP, which did not receive a claim during the period, can secure coverage under Scottsdale's policy for a subsequent claim is to comply with the notice of incident provision. That's the only way to hook a later claim back to the Scottsdale policy. My point simply is that compliance with that provision is a condition precedent to any successful argument that a later claim triggers coverage after the expiration of the Scottsdale claims-made policy.
So, counsel, given the fact that there was a request for records made and not an outright statement that there would be a litigation commenced, was, in your view, was WMOP supposed to go into its records concerning the patient and say, these are the allegations, that this was his condition when he died, or this is the reason why he went to the hospital were they supposed to dig into their own records, or were they supposed to wait until they received some type of further communication from the patient's estate via the attorney.
Thank you, Your Honor. Scottsdale doesn't have a specific position as to what the insured should have done. The notice of incident provision says that if the insured becomes aware of an incident, which is defined, that it expects to be the basis of a claim, meaning a demand for money damages, they must give written notice. Notice of incident must state the reasons for anticipating a claim with full particulars, including but not limited to, and it specifies 4 items of information: how, when, and where the incident took place. There was no indication of when the incident took place. I suppose you could divine that it occurred at the nursing home. The names and addresses of injured persons, the nature and location of any injury or damage. Now, counsel states that the location of any injury or damage arising out of the incident is clear from the submission. I would submit potentially that's not the case, but the nature of any injury or damage. The records request, as counsel has stated, has no specifics about any injuries that might have happened. It doesn't say when Mr. Eisner was a patient. Frankly, it doesn't even necessarily confirm that he was. And the circumstances by which you first became aware of the possible claim, that's also not clear from what was submitted. They could have received a call. There could be any number of other circumstances by which they knew that a possible claim could happen. So frankly, it's not for Scottsdale to divine from the virtually zero information provided that a claim would necessarily happen and all of these other things. It's Scottsdale's position that compliance with the notice of incident provision is a condition precedent, and frankly, we dispute that substantial compliance is the rule. I think the JP Morgan Chase case, the insured must adhere as closely as possible to the terms of the policy. The fact of the matter is, virtually no information was provided, and there are other cases holding that a mere records request is not, with no detail, no information, no description of a medical incident, is not sufficient to satisfy a provision. Now, WMOP—
I'm going to ask you to wrap up your argument because you're way over your time, and then we'll hear from Mr. Ham.
Apologies. I just would say that the reliance on Greenberg 11 School District for the proposition that substantial compliance is sufficient is misplaced. And I will rest on our papers.
Thank you. Mr. Ham, go ahead.
Thank you, Your Honor. Simple suggestion: if notice of all types is a condition precedent, then why was condition precedent stated with respect to the notice of claim? Why mention it? Notice of an incident is not a condition precedent because it is not stated with respect to condition precedent is not stated with respect to the notice of incident. And in terms of JP Morgan, there the underlying decision and this court's confirmance noted that they did the best that they could under the circumstances in providing details. So did we. We didn't have any more, but it's beyond that. I'm afraid I didn't raise this on my opening gong, but it's certainly in our briefs that there was also a statement called potential claim in the notice provision. It's under D, and the identification of potential claim is there's no identification of what you need for that. Now, while notice of incident is defined and the notice of claim is defined, potential claim is not. We would posit that Scottsdale and we and the court should recognize that there are occasionally circumstances where a claim is coming, or you can have an understanding that a claim is coming, even if you can't put out all the details that they're looking for in the notice of incident. And that includes the information that it was an information request by Finkelstein. It includes a statement on the documents that were submitted, which recite that it's for a lawsuit. It includes the information that says that it's going to continue until such time as the suit is finished. That kind of information manifests that there is a potential claim, and a potential claim should be enough to enable us to get past the 3211 motion.
Okay,
And I
thank
thank
you.
the court for its indulgence.
Thank you all. All right, the next case is Olaechia versus Mundy.
May it please the court, Jeremy Barberi from the Law Office of Bruce Lane, appearing on behalf of plaintiff appellant. I know that the court is well versed in the briefs and the records, so I'm going to keep this short. This is a psychiatric malpractice case. On the evening of January 14th, 2014, Gustavo Olaechia presented to Bellevue Hospital. He was discharged on the morning of January 15th, the next day. He went home that afternoon on January 15th and killed himself. I would like to turn the court's attention to page 50 of the record, where it states, quote, "This is the nursing assessment, the psych nurse's assessment on the evening of the 14th. Quote, wish to be dead, yes. In the past month, active suicidal thoughts, yes. In the past month, suicidal ideation with method, yes." End quote. In order for us to establish an issue of fact as to the defendant's liability, we needed to show that the defendants did not read or refer to Gustavo's records prior to his discharge. Defendant Malloy, who is the discharging psychiatrist, record pages 63 and 64, stated that Gustavo did not have any suicidal ideations until last night while high on PCP. That note clearly does not take into account the psych nurse's assessment that acknowledged the suicidal ideations for the month preceding his presentation to the hospital. To that end, even Judge Silver, in his factual summary, acknowledged, quote, "To be sure, the assessment of decedent at Bellevue Hospital includes notes indicating the following: wish to be dead, yes. In the past month, active suicidal thoughts, yes." And that's on record page 10. That is enough to establish an issue of fact as to whether Dr. Malloy's medical judgment was fully informed, because she never acknowledged the suicidal ideations for the preceding month as presented in the psych nurse's note from the evening before. As to causation, that note also creates an issue of fact, because all we had to show was documented proof of previous episodes of suicidal ideations in the days leading up to Gustavo's death. That note establishes that clearly. Now, in defendant's respondent's brief, they conflate those three questions: wish to be dead, suicidal thoughts in the last month, suicidal thoughts in the last month with ideation, into one question. They essentially argue that no, that note means he was having just suicidal ideations at that time. The first response, and this is in our brief, that I would say to that is that there's no evidence in the record to that effect. That is simply an averment by respondent's counsel. Furthermore, when questioned directly about that note in her deposition, defendant Malloy stated, quote, "I'm not present for nursing assessment, so I don't know how they ask it," end quote. That's on record page 804. The fact of the matter is that this note was never appreciated by defendant Malloy. Her own records acknowledge that fact, and in order to try and get around that, the defendant has conflated three separate questions into one. Going back to Judge Silver, in his factual, taking a step back, the opinion itself is internally inconsistent, His factual summary on page 10 of the record notes that Gustavo had these suicidal ideations for the month preceding his presentation to Bellevue. However, nowhere in the analysis does Judge Silver ever address that note. In fact, he goes so far as to say, and this is on record page 18, quote, decedent had absolutely no known history of PCB abuse and suicidal ideations. The opinion itself is internally inconsistent, and there are clearly issues of fact. Just to point out another inconsistency in the opinion, in the beginning, Judge Silver acknowledges plaintiff's EMTALA claim, Emergency Treatment and Active Labor Act claim. However, nowhere in the decision does Judge Silver ever address it, yet he dismissed that claim anyway. And just to drive the point even home even further, defendant's expert never once addressed plaintiff's EMTALA claim, yet it got dismissed anyway. At this point, I know I still have some time left. I would like to yield the floor to the court if you have any questions for me. If not,
You're actually out of time, but if my colleagues have questions for you, we'll take more time.
Yeah,
Okay.
I do.
All right.
I do have questions. So
Right.
thank you. Apparently the record said that there were no prior suicide attempts and there was no prior psychiatric treatment. These are considered important factors in assessing whether a person is likely to, whether a person should be held at the hospital. What do you say about this, especially given the fact that the patient presents with what's called PCP intoxication. He's observed every 15 minutes, and by morning time, when Dr. Malloy speaks with him, interviews him, examines him, he is calm, he's cooperative, he's talking about his future and his desire to live. So where does the nurse's note fit into this?
well, the nurse's note fits into it because her assessment of Gustavo was incomplete. And that's the point. She's assessing him from the perspective that he never had any suicidal ideations until last night. That's simply not true. And there's documented proof of it. Furthermore, the records indicate that at the time of his discharge, he was still sweating. Now, the defendants can argue all they want that that's part of a drop-down menu and it was left over from an earlier note. Now, I don't know if that's the case or not, but what I do know is I have documentary evidence that he was sweating at the time of discharge. Now, they can argue that's not true, but either way, that's enough to create an issue of fact to get past summary judgment. We literally have documented evidence that he was sweating when he was discharged.
How does the sweating create an issue of fact as to his mental condition?
Because it shows that he's withdrawing from PCP, that he's still under the effects of the drug, and that he was discharged anyway.
Okay, thank you.
Thank you.
Let's hear from Mr. Davies.
May it please the court, my name is Jameson Davies for the respondents. Supreme Court's order granting summary judgment to the defendants should be affirmed. Here, despite the tragic outcome, all the evidence in the record shows that defendants exercised proper professional judgment and acted within well-accepted medical practices in their evaluation, care, and discharge of Mr. Olacera.
What about counsel's, excuse me, sir. What about counsel's response to my last question about the sweating, that it's indicative of continued withdrawal, that the person is still under the influence of intoxicants?
Sure, two responses to that, Your Honor. First, as the testimony showed and the unrebutted testimony showed, that notation on the record merely pulled through what had been documented when he was first seen at the when he was admitted the night before. That's what Dr. Malloy testified to, and there's nothing to suggest that that's not how the medical record system works. And it makes sense because it gives the doctor a comprehensive look. She can look at that medical record when she's making the notation.
So you're saying that counsel was inaccurate when he was saying that on discharge he was still sweating. You're saying he was only sweating when he was first there.
That the testimony of Dr. Malloy, which is unrebutted, was that he was not sweating at the time that she examined him in the morning before she discharged him, and that notation on the record was likely a pulled through from the night before. But secondly, no one can link that to any causal. No one can make any causal connection between that and the ultimate outcome here. As everyone agrees, PCP does not have, even plaintiff's expert, PCP does not have physical withdrawal effects. And the plaintiff's expert doesn't make any kind of connection between the fact that, maybe he was sweating in the morning afterwards, but between that and his suicide, there's no evidence that shows that even if that had been true, it would have been malpractice to discharge him anyway, given Dr. Malloy's comprehensive examination of him. And I would like to point the court to pages 63 and 64 of the record, which detail in depth her examination of him and the fact that he was not.
How long did her examination last?
She testified, I believe that it lasted between 30 and 45 minutes. And so she went into great detail. And I think it's worth pointing out that the plaintiff's expert gives a list of sort of the questions you would ask of a potentially suicidal patient if you're going to meet the standard of care for treating a suicidal patient. And if you read her testimony, she goes into all those questions and more. She says she asked him all of those questions about his, whether he had any intent to harm himself. He was future oriented and forward thinking. He did not impress her as guarded or withholding in any way, denied any suicidal ideation. He had made an appointment to seek drug treatment in the next 2 days, and he told her how much he had to live for. I think that really the focus is whether or not her examination of him on that morning, given the detailed nature of it, would have led anyone in exercise of their reasonable professional medical judgment to conclude he was at imminent risk of suicide. And nothing there suggests that he was, Your Honor. I'd like to point to a couple of the things that were mentioned by counsel for the plaintiff. First, talking about the note, as Dr. Malloy testified, and again, this is unrebutted, that is a standard examination procedure that include the question, the way it's asked, is inclusive of the current thoughts. You can look at 803 and 804 of the record to see where she gives that testimony. And so there's no contradiction here between her testimony and that record. And also, to the point about the contradiction within Justice Silver's opinion, when he said no history of PCP abuse or suicidal ideation, he's talking about medical history, and it's undisputed that there was no medical history of either of those things. There had never been any previous admissions, as counsel agreed, for psychiatric treatment before. There had never been any previous hospital admissions or doctor's admissions that were in the record of his PCP abuse. And even if there were some contradiction, that doesn't affect the outcome here, because essentially there's nothing in the record to support that the decision to discharge Mr. Olachea was not within the bounds of the deferential professional judgment that psychiatrists, for good reason, are permitted under the law. Psychiatry, as the Court of Appeals.
If I may, you referred the record at where? 83, 84? Did you say 283, 284?
Sorry, 803 and 04 is her testimony.
803 and 04. Thank you very much.
Yes. As the Court of Appeals has recognized, the deferential professional judgment rule in psychiatry exists for a good reason. Psychiatry is a difficult and inexact science, and if to charge malpractice for any time that the ultimate outcome is not a good one would lead to a massive expansion of liability and lead to unnecessarily holding people against their will in circumstances where the law does not permit it or where they would prefer not to be held. And Mr. Olachea indicated that he did not wish to be admitted. There's nothing to support the idea that he wanted to be admitted and he wasn't allowed to be admitted. I'll lastly just touch briefly.
If I may, there was also outreach to his mother.
There was. Dr. Mundy the night before called his mother to let her know that he was in the hospital, that she did seem to take it amiss, that he would probably be coming home the next day after the effects of the PCP wore off. And so she was contacted that night when he arrived at the hospital by Dr. Mundy.
Okay, thank you. Any further questions, colleagues?
No, thank you.
Thank you both.
Thank you very much.
Thank you.
The next case is People versus Charles Little.
Yes. May it please the court. Mandy Jaramillo with the Office of the Appellate Defender for Charles Little. Mr. Little has maintained his innocence since he was first accused of this gunpoint robbery, and he easily meets the standard for a hearing on actual innocence. This hearing, however, was denied by the motion court. The standard for actual innocence is a sufficient showing of possible merit to warrant a fuller exploration by the court. And here, Mr. Little proffered a reliable witness. This woman, Miss Walker, had been giving a consistent account of what she had overheard since the time of trial and has been
Counsel,
spoken to now. Yes.
This is Judge Mendez. Did she provide a sworn affidavit?
Miss Walker.
Regarding her knowledge of what happened?
Yes, Ms. Walker did not sign a sworn affidavit. She did, however, speak to our defense investigator, and she spoke to the Bronx District Attorney's Office when the CIU reinvestigated this case. She spoke both, my understanding is, with an ADA and a DA's investigator present. She gave a consistent account to our office and to the DA's office about what she overheard. And she is really an unbiased, reliable witness in the sense that she lived in her building and worked with the tenant patrol with the NYPD officers there for 2 decades. She's a senior citizen. She's not biased towards either party. There simply would be no reason for her to make up this information. We do know, however, that she was hesitant to share the information and certainly to sign her name to an affidavit, that she was scared to get involved in this case, that she was aware of a criminal history of Mr. McCall, who Mr. Little has named as an alternate suspect in this case, and his brothers as well. And that, unfortunately, with bringing a 440 motion and bringing an actual innocence claim, you, as a defense attorney, certainly you don't have any power to compel someone to sign an affidavit, to make them sign a form. This is a common problem, even with police officers who are trying to get someone to be a witness, or prosecutors who have to bring out a material witness order. However,
if she refuses to sign an affidavit, what makes you think that she's going to come into court and testify if she doesn't want to get involved?
Sure, Your Honor. There is the power of subpoena. And frankly, there's the cover of the power of subpoena. So a woman who is older, who is nervous, who doesn't want to come and sign something and swear to something can be compelled to come to court once a hearing is ordered. And that, there is a difference in the standard between being able to get a hearing on an actual innocence claim and the standard that Mr. Little would have to prove in order to meet the definition of actual innocence. It's much, much higher, which of course it should be. At that point, if he is granted a hearing, he goes into the hearing convicted of the crime. He's guilty. So he bears the burden of having to prove his innocence with clear and convincing evidence. But in order to get to that point where he can have his day in court, the standard simply cannot be that he should have to prove his innocence on the papers. He is proffering what this court and what the Second Department in Hamilton, I think, would consider reliable evidence. This is a woman who really, if what she is saying is deemed to be credible, if her account is deemed to be credible, if she is compelled to come into court and her credibility is judged, is just unimpeachable in the sense that she.
So, counsel, you're saying that the contradiction between the alibi defense that he was at the girlfriend's house and his statement to Detective Russo that he was at or near Sin City that night, that doesn't play any role in this?
No, Your Honor, I don't think that it doesn't play any role. It certainly does. I mean,
and also the fact that he testified at the grand jury, right?
He did.
And he testified at trial?
He did.
But at the grand jury, he didn't implicate Mr. McCall in any way, right?
That's correct.
So how do both of those factors bear on what you're saying, that he should have had an actual innocence hearing?
Well, thank you, Your Honor. So he he did testify at the grand jury, and when he testified at trial, he admitted at that time that he had not testified in the grand jury, that he knew that Tristan McCall had his ID cards. And certainly that is something that this court pointed out when this court affirmed his conviction. It's something that the motion court below stressed as well. But he, Mr. McCall did testify at trial. He testified that Mr. McCall was his friend, that he was protecting him in the grand jury. He testified that he has always denied making the statement to the officer. And there were some issues with that statement. It was not recorded until several days after it was allegedly made.
What about, so going back to the investigator and Ms. Walker, so we're talking about hearsay, of course. And are we getting into double hearsay as well? So Mr. McCall never said, I did it. And he supposedly said that he had the cards and he left them in a cab, which is not the vehicle that the defendant was driving. Sorry, the complainant was driving here. So that doesn't bear on the need for an actual innocence hearing?
Well, I think that it does bear on the need, and I'd like to try to clarify, I think, her account. So what she said to our investigator and what she said to the Bronx DA's office, Ms. Walker, is that what she heard was a conversation among Tristan and his friends, where Tristan admitted that he had wronged Mr. Little and he left his ID cards behind in a cab. And he apparently did use the word cab, or that's what Ms. Walker heard. Putting the whole thing into context, there's just no way that it could be referring to any other incident other than the incident at hand. He would not have been able to leave Mr. Little's ID cards in more than one car. That simply doesn't make sense. So in the context of this case, yes, he essentially is.
Could Mr. Little have had more than one set of cards? Could he have had more than one set of cards, Mr. Little?
Does he? No, he did not have more than one set of the cards that were at issue in this case. So this was an EBT card that had his photo on it, and then there was also a debit card. Those cards he did not have in his possession at the time, once he was arrested. So those were the two cards that were at issue, and there was never any question about whether it was other cards or whether there could have been additional cards. And so. In addition, and I know that I am running a little short on time, I would like to just quickly touch base on the other issue that we've raised in this brief. As this court is well aware, mistaken eyewitness identification is the single greatest cause of wrongful convictions in our country. And defense counsel here, in a case made, in an identification case made by a stranger of Mr. Little, this is a single identification, a cross-racial identification. Defense counsel did not consult with an eyewitness identification expert, nor put on any testimony to try to educate the jury about an extremely damaging part of Mr. Little's case.
The issue of eyewitness identification, the Court of Appeals has written a robust amount of law on this, correct?
Yes.
And it's within the trial court's discretion, even when you ask for an expert, whether you're going to get one, right?
Yeah, well,
and it's usually limited to circumstances where it's the sole or primarily the only evidence that connects the defendant to the crime, right?
Yes, Your Honor, it would be an abuse of discretion if there's little to no corroborating evidence. And we certainly argue in this case that there is very little corroborating evidence, where the Court of Appeals has been clear that the corroborating evidence cannot also be sort of wrapped up in the identification. Here, obviously, Mr. Little's ID cards were found in the back of the complainant's car,
right, but that's a separate fact. That's not a fact related to eyewitness identification. That is a separate corroborating fact. Your client may have an explanation that he now wants to give as to why they're there, but that has nothing to do with whether the cab driver could identify the person who robbed him, right?
No, respectfully, Your Honor, I would disagree with that assessment. And I think that that is exactly why there should have been an expert here who either consulted with the defense counsel so that she could have been aware of how damaging this was to the identification. This entire identification really turned on the fact that the complainant woke up the next morning in his car, looked in his back seat, found a photo of Mr. Little, looked at it, walked it over to the precinct, and 15 minutes later picked Mr. Little out of a photo array.
Yeah, but there's more than that. Isn't there more than that? Didn't he get to see him face to face as he was handing over his possessions? And he saw them on more than one occasion. I mean, there was sufficient time for him to have recognized the person that was in his car at the time. He even went into the front seat. And according to the testimony, they got so close that the complainant could actually kiss him if he wanted to. So that's that's pretty strong information. That's pretty strong testimony as to how long and how close they were to each other, that the complainant could see who it is that was in his car.
Your Honor, I'd like to address that in a couple of different ways. The first is just to point out that the complainant here, who had just left a strip club in the Bronx and then fell asleep in his car for 8 hours after this incident occurred, testified to several different sort of ways that this incident occurred. When he told the police about it initially, and what's in all of the police reports, which is in the appendix here, is that the perpetrator first came into his front seat. However, when he testified to this at trial, it was a completely different account of how this happened. He came into the back seat. He had been sitting there on the phone. So it's not like he has given an extremely consistent version of what occurred from the beginning. So that's the first way I'd like to address that. But the second point here is that this is exactly, the type of factor that I think an expert could explain to the jury that is really quite damaging. It was very dark out. It was 1 o'clock in the morning. There was no light except what was illuminating from the dashboard. This was a black man being identified by a white Hispanic man. He said that he had a few moments to look at his face in a few different instances, and he was holding a gun up to him. So there's this issue of weapon focus. There's an issue of an enormous amount of stress in the middle of the night with very little light. So I think the idea that where cross-racial identifications cause something like 42% or play a role in 42% of cases where wrong IDs are made, that we can rely on this identification with all of these other risk factors as well. And if the court has no further questions, I can wait till rebuttal. Thank you.
Thank you.
Good afternoon. This is David Slott from the Bronx District Attorney's Office. May it please the court. I'm just double checking I can be heard and seen. Is that correct?
You can.
Thank you so much, Your Honor. The motion court properly exercises discretion in denying defendant's 440 motion, both for ineffective assistance of counsel and the actual innocence claim. I'll follow the lead of my respondent, of appellant, and address the actual innocence claim first. As the motion court said, defendant's motion was not supported by sworn non-hearsay allegations from the source of the information. And that is exactly what was requested and required by this court in Jimenez, where this court stated an actual innocence claim must be considered in the light of any 440-10 motion. Statements of fact must be sworn, and hearsay statements are not probative. So without directly saying it, appellant's asking this court to overrule itself, to overrule Jimenez. There's no way to square what they're asking for and what they're arguing here with Jimenez. And I think we can all agree that there's a significant difference between talking to an investigator, talking to someone from the district attorney's office, versus signing your name to a court document under penalty of perjury. This court recognized that difference. The legislature recognized that difference, which is why it's required. So, the defense team met with these witnesses, Ms. Walker and her caretaker, and they presumably could have written an affidavit. There's nothing wrong with an attorney drafting an affidavit and present it to this witness for her signature. Not only do we not have an affidavit from her or other witnesses, which I'll talk about, but there's absolutely no explanation why she did not sign whether it was offered to her by defense in preparation of this motion, and what her answers were, what her reactions were. We're of course speculating that she wants this cover of subpoena, but that's not anything that was elicited from this witness. So not only do we not have an affidavit from Ms. Walker or her caretaker, we don't have a affidavit from the defendant who testified in the grand jury and at trial. We don't have it from any of the alibi witnesses, one of which the people were able to speak to after the trial, and so was trial counsel. And we don't have any affidavit from the person who allegedly did it, Tristan McCall. Not that he necessarily would give one, but there was not even an attempt or explanation. And by the time this was filed, the statute of limitations had passed, so he might have had that covered. Hearsay issues aside, the statements aren't exculpatory, and I disagree with appellant's characterization that these were a consistent account from Ms. Walker. In respondent's brief, page 35 to 36, I go into more detail, quoting exactly what Ms. Walker says each of these occasions and how her story has evolved. But essentially, and I encourage the court to look at that, but it goes from unknown people talking about an EBT card to Tristan chuckling when people are talking about it, to Tristan actually talking more, not just chuckling, but saying he left his identification in a cab. That's the first time a cab is mentioned in this entire case, which was years after the verdict, and it comes from Ms. Walker. And the most recent version is that Tristan lent the EBT card and accidentally left it in a cab again. So there's this evolution here, and they don't support the claim of actual innocence. It's just a repackaged version of what the jury heard, and so this court should reject the attempt to consider it under an acting in concert, actual innocence claim. With respect to the ineffective assistance of counsel, defense put forth a truly vigorous defense throughout this trial, faced with enormous odds, faced with a defendant, a client who was insisting on testifying to an alibi defense with no alibi witnesses, to really coming off the bat, and he said he lied in the grand jury, right? So if he lied in the grand jury, that's a big strike against him and a big mountain to climb for defense. She put forward many different points and hit almost all the points that were mentioned by the expert in this case. Perhaps it would have been nice to have the academic label of these things that defense was arguing, such as post-event information, but that was argued throughout the case by defense. And the question's not whether the expert testimony would have been helpful, it's whether not consulting amounted to incompetence or less than meaningful representation. And Your Honor was correct that even whether or not the testimony from an expert witness would come in, that is up to the discretion of the court, and there is corroborating evidence here, not only the actual IDs in the back of the witness's car. I would argue that it's also corroborated by his admission that he lied in the grand jury, his statement to the detective that he was in the vicinity of the crime at the time, as well as his flight from police and parole for 3 months after this case. Just one last mention, it was brought up that this was a cross-racial ID. That argument is based on the fact that in the police report, the complaint report, which is then that information is populated in additional reports, that the complainant is described as a white Hispanic. There's nothing in the record describing this as a cross-racial identification, and the defense attorney was offered this opportunity. She submitted an affidavit, and rather than saying, information on cross-racial identification would have been helpful or any of that, the only thing she pointed to was post-event information might have been helpful to the case. She was dealt a difficult hand to play and performed admirably, in my humble opinion. In the face of the defendant's story and explanation for these cards in the car, which this court previously called highly implausible. If there are no further questions, or if there are no questions at all, I yield the rest of my time and rely on my papers. Thank you.
Any questions, colleagues?
No.
Thank you. All right, rebuttal.
Yes, thank you. So I will start quickly and try to get through a couple of points here, both with the actual innocence hearing standard and the ineffective assistance point. This court in People versus Jimenez, as this panel knows well, did find that the actual innocence pleading standard should follow the 440-30 statute. And that simply requires that statements of facts supporting the motion must be sworn. It does not require that every particular witness needs to sign an affidavit. And so I think that is the question.
Standard? This is Judge Mazzarelli. I'm a little familiar with the.
Yes.
How is that standard met here?
Well, that standard was met here several ways, and frankly, this is a unique set of circumstances. First of all, you know, we would certainly argue that our defense investigator is a reliable witness who did speak to Ms. Walker, and we spoke to Ms. Sanchez. But the DA's office here also sat down with these witnesses. You know, that's the DA's office with an investigator would have had a chance to judge their credibility, and then wrote a letter to defense stating, yes, Ms. Walker gave this same consistent story to us. Ms. Sanchez, you know, confirmed Mr. Little's alibi. So these are not just statements that were sort of overheard. This is a different case than someone who says, you know, this witness said X. This is a case where these are certainly with Ms. Walker, you know, someone who's been saying the same thing.
But the district attorney's unit found it not sufficient to proceed.
Right, they made a credibility determination, right. But it's certainly, it's certainly not, you know, ultimately up to them if we are going to bring a motion on this.
You're using them to buttress your position, but they didn't find your position credible.
But what they could not deny, Your Honor, is that this witness, who could certainly be brought before a court, made the same consistent statement and has been making that statement. Ms. Walker, I do want to just address again, the fact that she did not sign an affidavit. I mean, she has expressed apprehension about being involved in this case, about being involved in a case that potentially involves Tristan McCall, who she overheard, who has been, she has not said that he has been convicted of a robbery, but these young men grew up in this building. She has been a longstanding community member there. She knows that family. And she has said from the time of trial that when she spoke to one of her NYPD tenant patrol friends who she's worked with, he cautioned her not to get involved. She has not wanted to be involved in this case, and she was not willing to sign an affidavit. And to move quickly to the ineffective assistance of counsel point, the defense counsel here certainly did put on a defense. There's no question about that. However, she did not in any way address the cross-race effect here. And it is frankly a little shocking to me that the prosecution is now arguing that there is no cross-race effect here. They did not deny that in the direct appeal. It is clear in every single police report that the complainant is a white Hispanic man and that Mr. Little is a black man. So I don't think that there is actually a question that that was an issue here, and defense counsel didn't address it. The other thing that she really frankly was sort of operating in the blind on is this idea of witness confidence, how it's malleable, how it changes when there's post-event information that sort of buttresses the initial identification. This is a case where the complainant took the ID card to police and testified, I didn't have to give them a description because I handed them the ID card. I didn't have to give a height. I didn't have to give a weight. I just said it was a black man and handed them the ID card. But then when he testified at trial, he said that the perpetrator was a lot taller than him, a lot bigger than him. He's a small man. He's 5'4" tall. But Mr. Little is only a few inches taller at most and quite slight as well, about 150 pounds, whereas Mr. McCall is 6'1" and 220 pounds. So this is a problematic description to a start.
Counsel, didn't the complainant say not a lot taller, but real taller and just bigger?
He did. Yes,
so I don't know that that translates into a lot taller, just to clarify that point.
Yes, no, that's true. He said real taller and bigger, and he also said I didn't give no height and no weight when he went to the police station, that he just handed them the ID card because he didn't need to give a description. So in other words, I do think if Ms. Tobia, the defense counsel here, had consulted with an eyewitness expert, she would not have sort of put on this defense without the knowledge, both of what sort of social science research says on these topics, but also she was kind of flying in the blind in the face of Court of Appeals precedent, which has been very clear in People versus Santiago and People versus LeGrand and Abney, that witness confidence and that malleability is a major point in these cases. And if there are no further questions.
Any questions? Thank you. Thank you both.
Thank you, Your Honor.
Right, the next case is Vitkina versus Benalou.
Good afternoon, Your Honors. May it please the court, Martin Karlinski on behalf of the appellant, plaintiff below. Your Honors, this appeal starts and ends with a single indisputable fact. The case that plaintiff Vitkina commenced on August 2, 2017 was an action within the meaning and dictates of the CPLR. For that reason, the lower court's dismissal of the action on the ground that it was instead a special proceeding in which all relief sought had been denied was wholly improper and should be reversed. Plaintiff commenced the case by filing a summons with notice squarely within CPLR 304A, which of course provides, among other means of commencement of an action, that, and I quote, an action is commenced by filing a summons with notice, close quotes. That summons with notice, Your Honors, is in the record at 37. The summons with notice was accompanied by submission of a proposed order to show cause, an OSC. The OSC sought an order permitting plaintiff to proceed anonymously and on a sealed record. It was based on, among other things, the summons with notice. It was signed by the court, and it was duly served on the defendant. The order to show cause was made and filed strictly in accordance with the prescribed written procedures of New York County Supreme for obtaining an order to proceed anonymously and on a sealed record. And of course, that procedure is obviously designed to permit an anonymous and sealed filing while the court determines whether the case will continue in that manner. The court denied her application to proceed anonymously and on a sealed record by order dated June 3 of 2018. I note parenthetically that Supreme Court took over 215 days, over 7 months, to decide this threshold issue, which basically put the case on hold for 7.5 months, and of course violated 2219A as well. From that order, plaintiff filed a timely notice of appeal from the June 3 order, that is, and finally elected not to perfect the appeal. Instead, on November 29, 2018, plaintiff filed a summons with verified complaint in the true names of the parties, and that's in the record at 39 to 62. Shortly before that filing, the court had scheduled a status conference. Counsel for defendant appeared at that conference. She was heard by the court's law clerk, not the justice, and she argued that since the case was a special proceeding, which it was not an action, and since the court had denied the relief sought in that special proceeding, that was the end of the case. She argued it had terminated by reason of the June 3, 2018 order. The day after the conference, December 3, 2018, Supreme Court entered what it styled an amended order, and that is the order appealed from to this court. That's in the record at 4.
For just a moment, and it's
Yes,
just a
yes,
small procedural point.
Sure.
So the amended order was made sua sponte after a conference There was no motion before the court for that relief, was there?
It's a little unclear, Judge. There was a motion originally, of course, to proceed anonymously.
But that
And
was
this amended
disposed of.
that, I'm sorry?
But that was disposed of. That was disposed of in June.
It was, yes, it was disposed of in June. But this order amended that order. So I'm not certain this was sua sponte. There wasn't a notice of motion served. That's true. Certainly that's true. And by the way, I also think it's true that there's absolutely no impediment to appealing under 5704A from a sua sponte order. We didn't fully brief that in our reply brief, but it was raised by respondent. There is a body of law out there under 3211 that is very clear that a plaintiff may elect to proceed either under 5704A or in another manner from an order that was entered sua sponte. And I could provide the authority to the court following the argument if the court would grant leave for a letter. Let me return to that conference and the amended order, Your Honors. Accepting that contention that the case was a special proceeding and not an action, and that all relief sought by that proceeding had been denied, the amended order dismissed the case. Your Honors, this was error of the most fundamental kind. It is this error that the appeal raises, and we make 3 points. 1, the case was indisputably an action commenced by filing a summons with notice under 304A. And for that point, we rely on the plain record. 2, the appeal is proper under CPLR 5704A. And there too, we rely on clearly applicable law, and as well on the law of the case doctrine, because respondent moved to dismiss the appeal on that ground, and this court denied that motion. That is the law of the case. And finally, 3, we contend that the case was timely commenced by the filing of the summons with notice.
Can I need to step back just a bit.
Certainly.
On the law of the case. When and where that motion was made to the appellate court on the prior appeal?
No.
On this
Your
appeal?
Honor, it was made on this appeal to the First Department. And it was denied.
But just says motion denied. They asked to dismiss.
There was no
the
reason
appeal.
given. You're right. Correct, Your
Okay,
Honor.
so, all right. I don't really think that's law of the case, but that's okay. Your third ground?
That was my third ground, Your Honor. My third ground, I'm sorry.
The second
I'm sorry.
ground is the 5704A.
Yes,
Right.
that was my second ground.
Okay.
The third ground was that the case was timely commenced by the filing of the summons with notice. And again, we rely on very clear law on that point. And specifically, I would point the court to Article 2 of the CPLR and to the statute of limitations, which has been provided by the New York City Council's Act, which is called the Gender Motivated Violence Protection Act. All of those points are fully briefed in the papers before the court. With all due respect, Your Honor, the order below should be reversed and the case remanded. And with that, unless the court has questions, I'll yield the balance of my time.
Any questions, colleagues? Yeah, oh, by the way, there was no balance of time, Mr. Kurlinski. I gave you extra time so that you could make your argument. All right, we'll hear from Mr. Isaac.
Good afternoon, Your Honor. It's Brian Isaac. I represent the respondent in this matter. I have to confess, I've had a very, very difficult time understanding the record. And Justice Gish, just in the interest of candor, I did make a motion to dismiss the appeal. This court did deny that motion, but did not. That doesn't preclude me from raising this issue. To me, this is a sua sponte order based on what the plaintiff said. If you read the order, it's on page 4 of the record. It says, upon the foregoing paper, it is ordered that this special proceeding by petitioner seeking to seal the court file and proceed anonymously is resolved by decision in order dated 6/4/18 and entered 6/11/18. It doesn't facially dismiss the case, although I have no reason to deny what my adversary is saying. And as you know, there was a notice of appeal filed by the plaintiff from the 6/4/18 order, which is now dismissed because it wasn't perfected. He says in his brief that he has every right not to perfect the appeal. He absolutely does. I withdraw appeals all the time. but you have to withdraw the appeal. You can't allow it to be dismissed that you have problems under Bray-Rubio. And the problem here is this record was not before the court. It's just a conglomeration of different motions that were put together by the appellant because there was nothing before the court. Under 5513 to 5521, the record on appeal is the papers before the court. The only paper before the court was no paper. So if this was a true record, you'd have page 4 and that was it. And as I read Scholes against Mager, the Court of Appeals has said without a notice motion, this isn't appealable. You can always grant leave to appeal, but you don't even have a notice motion here. The other thing is—
So in other words, let me just follow that up.
Sure.
Your position would be that where the court, and courts do make sua sponte motions or orders all the time at conferences,
Sure.
that the party who's dissatisfied has to go back to the court and make a motion to get what we call appealable paper.
Correct. You make a motion to vacate, you put in all of your arguments, and then you appeal from that. There's no untimeliness problem.
Right, and that's conventionally. Is there any exception to that for 5704, where an ex parte order is made?
I don't think you can make. I mean, 5704A relief, as you know, I don't have to tell you, is an extraordinary kind of relief. Generally, we use it when a trial court judge doesn't sign an order to show cause, and then you can go up.
Or denies a TRO, strikes the TRO in an order to show cause. But that doesn't mean it's its only exclusive use.
That's true, but my adversary didn't raise it in the main brief, didn't really raise it in the reply brief, as he says. And you at least have to make application for it. You can't make application for it for the first time on an argument of an appeal. That doesn't seem to me to be particularly fair. The other thing, Justice Gish, is my adversary keeps saying that service was made. Maybe it was made, but I don't think it was made on this record. If you actually look at the order to show cause, page 98, this is what it says. Last page of 98 and going to 99. Ordered that pending the hearing of this order to show cause before the justice to be assigned, the clerk of this court, upon payment of the proper fees, be and is hereby directed to assign an index number to this proceeding. It's all under one index number. That's 156923 of 2017. I'm sorry. And to accept for filing a request for judicial intervention bearing the caption, and the caption is in a pseudonym. And the last paragraph of page 99, it says, ordered that personal service of a copy of this order to show cause together with the papers upon which it is based, and the summons with notice, be served upon defendant AB on or before the 31st day of August. The only affidavit of service that I see in this record is on page 100, the next page.
Well, yeah, but let me stop you there. You don't need to you don't need to serve a proceeding for it to be commenced. It needs to be filed. It needs to be. Right, that triggers commencement under the CPLR, and in fact, the procedures that we're talking about really grew up in domestic violence cases, so that somebody could commence an action and start off right off the bat anonymously if they had to, or at least ask the court for that protection at the beginning of the case. But that doesn't resolve the whole case. That's
I'm sorry. I'm not disagreeing with you. That wasn't my point. I agree. What I'm saying is if you look at page 100, because this is why it's so important, the affidavit of service only talks about an order to show cause. The notice, the order to show cause was in the disjunctive. It was and. It doesn't look like the summons and complaint or the complaint were ever served in this case. It says on page 100 from
but that's not why the case was dismissed, though, was it?
It may not be, but what I'm suggesting is that if the defendant, if the plaintiff follows the proper course, we can actually get a disposition on the merits. We'll know whether or not service was properly effectuated. We'll know whether or not there was service within 120 days. We don't know these things here because you're dealing with a sua sponte motion that wasn't made on notice, and we can get a resolution of the case instead of having a piecemeal resolution of the case. So it seems to me that in a case which is purely sua sponte—
Well, it wasn't his, to be fair, it wasn't your adversary's motion. It was your client's motion. It was your client's motion at a conference because the case had been commenced. It was floating around with an index number in the court system, and the court wanted to kind of keep track of it to find out what was going on, right?
That's right. But I mean, we have motions, as you said, all the time where judges make sua sponte decisions without appealable paper. And that's why the court has held that the appropriate first department, second department, court of appeals, doesn't matter what court it is, you make a motion to vacate it so you identify the issues, you have a proper record, and you're not guessing at what happened or what didn't happen. I'm not blaming my adversary for what happened at the conference. What I'm saying is that appealability is still important because it leads to a fair resolution of appeals on the merits as opposed to us guessing.
All right. Any questions for Mr. Isaac? Okay.
Thank you, Your Honor.
Thank you. Thank you both. Okay. Bamberg Taylor versus Strouch.
Good afternoon, Your Honors. Peter, can I be heard?
Yes.
Okay, thank you. May it please the court, Peter Paretsky, appearing on behalf of the appellant in this case. In 2013, this court, in the case of Arcado versus Metro North Railroad, which is cited in appellant's brief, clearly held that an unsworn expert's report submitted by a defendant in support of a summary judgment cannot be cured by submitting a sworn report in reply. Therefore, the language in defendant's expert's affirmation in this case cannot be cured, as it does not comply with CPLR 2106A. The only First Department case relied upon by the trial court in this case is Dabao versus Newmark Knight. However, the trial court erred in its decision in its reliance on Dabao because it is procedurally distinguishable. What is similar is that the court in Dabao considered an unsworn affidavit of a witness. However, what is completely different is that the affidavit in question in Dabao was not submitted by the movement to establish a prima facie entitlement to summary judgment. Rather, the affidavit in Dabao was submitted by the non-moving party to raise an issue of fact in opposition to the.
You don't consider, this is Judge Gish, you don't consider these technical defects that we can clean up, that we can allow to be within our discretion cured?
This same court in Arcado didn't consider it a technical defect. In the 2013 case I cited, Arcado versus Metro North, it clearly said.
But don't we have more recent cases where we're taking a more liberal view of that from 2019 and 2020, where we allow those technicalities to be cured?
There are certain technicalities that can be. An unsworn deposition transcript certainly is one of those examples. But when you're speaking of something so significant as an affidavit or an affirmation that must be sworn under penalties of perjury pursuant to the CPLR, it's not a technical defect. That's why the court didn't find so in Arcado versus Metro North.
So are you hanging your whole appeal on that?
I am not, but I do believe that the trial court relied on a case that clearly does not apply. The trial court relied on a case where the affidavit was cured in opposition to a motion.
All right, I know, but you only had 3 minutes to argue, and all right.
If I may continue, I have other arguments to make aside from that. I'd like to.
You're out of time, honestly, but I'll give you another minute.
Okay, the case of EPF.
And by the right, I'll give you another minute.
Okay,
go ahead.
Before that 1 minute begins, I just would like to make sure the
No,
court.
no, the minute's already started, sir. Please.
Okay. Sure.
You know. All right.
The court overlooked the trial court overlooked several claims made in plaintiff's papers. The court overlooked claims in plaintiff's bill of particulars. The court overlooked plaintiff's argument that the informed consent form was generic as plaintiff's expert cited to, as was submitted in plaintiff's expert's report. The lower court failed to accept as true the facts presented by the movement. And concluding, I would just like to say that this is not a case, although defense counsel tries to present it as though as a case of just whether whether plaintiff anticipated there was scarring or not. It's the location of the scarring and the extent of the scarring, not that there was just simply scarring.
Okay, thank you. All right, we hear from your adversary.
Good afternoon, Your Honors. I'm Judy Shamitzi from Wilson Elster. I do ask that the order on appeal be affirmed. I would like to very quickly address the expert situation. The plaintiff's case of Accardo is very easily distinguishable. What happened there is the defendant put in the expert's report, only the report, in their main motions, and that is a problem for defendants when they do that. And then on reply, they tried to do an affidavit or an affirmation from the expert to retroactively validate the report that they had put in initially. That is not what is happening here, and that is not what's happening in any number of other cases where a technical defect of an existing affirmation or affidavit is permitted to be cured. So what is happening here is they put in an affirmation from an expert who swore that this was going to be true, but not under the penalties of perjury, evidenced his understanding that his words would be submitted to a court in the context of a summary judgment motion, and then submitted exactly that same expert opinion, that same evidence, with the missing phrase missing. That is a technical defect, and it should be permitted to be cured. And similar defects have been cured in many, many cases.
So the only thing that was added were the words under penalty of perjury?
Correct, Your Honor. The expert said that he affirmed, but he didn't affirm with the whole phrase, affirm under penalties of perjury. And Your Honor, I was thinking as I was prepping, I remember not that long ago sitting in Your Honor's courtroom as somebody tries to introduce whatever piece of evidence it is, and they stumble and they don't hit all the marks, and there's an objection to its admission. And usually the defendant is permitted a second go around, or whoever's trying to get the piece of paper in, or whatever it is, counselor, you want to try again. I was sort of reminded of that dynamic here. That's different from not setting it up at all, from not even trying on an initial motion paper to get your evidence into admissible form.
If I may, Judge Mazzarelli, first I'd like to compliment you on the fact that you've straightened out the United States behind you.
Thank you, Your Honor. I do appreciate that.
Yeah. But secondly, if you're not swearing under penalties of perjury, you're not swearing at all. I mean, I understand your argument about correcting it as a technical defect, but really to swear, I swear, doesn't really have any meaning in the abstract.
I would say this, Your Honor, to that. I think that the standard for that is whether the affirmation or affidavit taken as a whole, which we do with experts, right, when they give their opinions and they forgot to use the magic words to a reasonable degree of medical certainty. We read it as a whole and we ask, does it sound like they mean that, even though clearly they stumbled over the language? I think that the proper measure of that is whether as a whole it evidences that it has awakened the conscience of the affirmant, which by the way is the CPLR standard for an affidavit, right? So I think that when you look at it that way, it's clear that it has, and that's why I'm saying the defect is technical.
You've used all your 3 minutes on this defect. I'll give you another minute on the merits here.
Thank you, Your Honor. I would like to say, with the extent of the scarring, the distinction I'm drawing is not whether she knew that she was going to scar, because she clearly said in her affidavit that she knew that she may. The plaintiff has never claimed that she was cut anywhere where she wasn't marked. Now, I'm leaving aside the marks on her belly, which are from bypass, which my experts said, and they failed to refute. I'm talking about the scarring around her breasts and down her breasts. She was cut where she was marked, and she knows that she may scar where she's going to be cut. So in reality, it simply doesn't add up for her to say now, well, I didn't think I was going to be scarred that much, but she knows, and she testified, it's at 244 and 254 of the record, that she knows that she was marked, and there's been no claim that she was cut anywhere other than where she had been marked. And otherwise, Your Honors, I'm happy to rest on my brief.
Any questions, colleagues? Okay. Thank you both.
Your Honor, one thing. It's not an argument, but I just want to make sure the court is in possession of appellant's reply.
We are, okay. Sir.
Thank you.
Great. We have it, as well as some additional authorities from your adversary.
Thank you, Your
We
Honor.
have it all. Thank you. Okay, the estate of Daniel and Chuagi, I am sorry again, versus the city of New
Enchitegi.
York. Say it again for me.
Enchitegi.
Enchitegi. Okay, thank you.
May it please the court, good afternoon, Your Honors. Christopher Della Carpini for the appellants. I'd like to start with the city's argument that it cannot be liable for anything that happened to Officer Enchitegi here based on Cuffey. And to that end, I'd like to point out a decision of this court that was handed down last Thursday in Xenius versus City of New York, which I emailed to the city's council that same day. The site is 2021 New York Slip Op 00647. It's a case with very similar facts that shows there's at least issues of fact here as to whether the city had that special duty under Cuffey. The city here argues that the 911 operator's representations to Officer Enchitegi did not assume a duty. But in Xenius, the 911 operator said to the plaintiff, "We are on our way." And that was held sufficient to establish the assumption of a duty. Here, the operator said to Officer Enchitegi, "Assistance will be there soon as possible."
Counselor, if I may just ask you one question, just so it's clear in my mind. Where was the officer when he made the call?
He's outside the house where the burglary was happening. He's either on the sidewalk or on the street, facing the front of the house.
He didn't make the call from inside the house and then go outside afterward, is that correct?
No, he's on the street the whole time, apparently, till the end. So as a,
You also, this is Judge Gish,
Yeah.
you know, because I was on the Xenia, and in that case, the statement was, "We are on the way," or something to that effect. And that was apparently what you alleged in your complaint, but as the record developed, the operator said actually something a little bit different. Can you tell me what it is that the operator said to your client when the call was
we
made?
transcribed this. It's on page 14 of our brief, but the CD is in the record as well. The operator says, "All right, assistance will be there soon as possible." To which Officer Enchitegi says, "All right, I'll be there, all right?" The officer said, "All right, Mr. Enchitegi, in front." If there's
Well,
any...
I just want to be clear, you believe help is on the way and assistance will be there as soon as possible are functional equivalents.
Well, I believe that, but more importantly, if we are parsing the difference between what those two phrases mean, we've invaded the province of the jury. That's construing inferences, and that's not what we're here to do on summary judgment. Those inferences have to be construed in favor of the non-movement, the appellant. If I can move to just the other elements of Cuffey that the city brings up. They deny that Officer Enchitegi justifiably relied on the operator's assurances. Again, if you look at that transcript, the operator says assistance will be there as soon as possible. Mr. Enchitegi says, "All right, I'll be there, all right?" This is two people making arrangements. They're making plans together. If there's any way to construe that as not justifiable reliance, again, that's an inference being construed, and that has to be construed for the non-movement here. Yes.
What did the officer do after he made the call that shows his reliance? What were his acts in reliance on the statement? Says maybe a better way for me to phrase that.
He stayed there until they shot him.
He was already there. He was outside.
He was outside, yes.
And he was in front of the house as he's making the call to the operator.
That's right.
So it's not as if he was somewhere else and he went to the front of the house based on the call he made to the operator and the response he got from the operator.
You're right. You're right, Your Honor. He made the call outside. He heard assistance was on the way, and then he stayed. And if you look at that transcript, I think it at least admits to the inference that he stays because of what the operator says. Imagine if the operator said, "Well, we don't know when we're getting there." Does he stay? Well, what we have here, if you look at that transcript,
it goes back to the statement from the operator, assistance will be there as soon as possible. It doesn't say assistance is on his way or will be there right away. He doesn't say that.
That's true. That's true. It says assist will be there as soon as possible. I certainly don't see anything in Xenius to make a distinction between those two phrases. I really think this is a question of inferences. I don't know how you could say as a matter of law that assistance will be there as soon as possible is not assuming a duty.
You know, Cuffey is a very hard principle, and this court has, on a number of occasions, the Relato case from this court, we were reversed on that handily by the Court of Appeals. And so the law is pretty clear about the special duty and the reliance. You know, we don't have that much. You have a very high hill to climb, Counselor, is what I'm saying.
That's true, Your Honor, but I think you hit the nail on the head in the Xenius decision. If we are on our way is somehow a reliance, I don't see how assistance will be there as soon as possible does any less. But again, if we're parsing the language, I think that's for a jury to decide. If I could move on. The last thing the city
your time has elapsed, but I'll give you another minute to wrap up.
Thank you, Your Honors. The city talks about how its coding of a 911 call is discretionary rather than ministerial. There's no case law on that. There's no affidavit from anybody at 911 to say that. And certainly the police officers understood, and our expert pointed out the need to code this call correctly based on the evidence. The city talks about how there was an intervening cause or intervening act that broke the causal chain, namely the shooting. For that to be the case, the shooting would have to be an unforeseeable or not preventable consequence of the burglary. Your Honors, burglary is a violent crime. Violence is always foreseeable for someone who comes upon a burglary in progress. And that's what Mr. Officer Enchitegui was telling the 911 operator.
Well, did he actually say that there was a burglary in progress? Was he specific on that, or did he say something equivocal?
Here's what he said. What's the address? Officer says 3119 Arno Place. I'm not sure if they're still in there because nobody was living there. Now he's already testified there's broken glass outside. Nobody's lived there. Now there's broken glass. He's heard it. Again, you can make inferences from the circumstances, but that's not our place here. Last thing I'll say, the city argues the firefighters rule categorically bars this negligence claim here. The firefighters rule applies where the injuries sustained are a result of the risks that we expect the service member to assume in the course of their duty. Officer Enchitegui was off duty. He was calling in to 911. He wasn't radioing in for backup. He was doing what you or I would have done on the scene had we found somebody breaking into our neighbor's house or evidence suggesting a break-in in progress. The city offers nothing to suggest that we expect officers to take a bullet when they're off duty. And yes, maybe Officer Enchitegui did what he did because in some sense, a police officer is never off duty in his heart. But this is not an injury from a risk we expect off-duty officers to sustain. If there are no more questions, I'll reserve the balance of my time for rebuttal.
You have no more time. Everybody's reserving the balance of no time.
Thank you very much.
But okay, I gave you actually more time, but
I appreciate it.
Thank you. Anybody have any questions? All right, we'll hear from your adversary, Ms. Fletcher.
Good afternoon. May it please the court, Kate Fletcher for the City of New York. Your Honors, I would submit that this court does not need to reach the special duty issue. The firefighters rule bars plaintiff's common law negligence claim, and they failed to identify a violation of a proper predicate for liability under General Municipal Law 205E. As an initial matter, contrary to plaintiff's assertions otherwise, the city argued below that the firefighters rule barred plaintiff's common law negligence claim, and Supreme Court explicitly ruled that in fact it did. Yet plaintiffs did not dispute below or in their opening brief on appeal that the firefighters rule applies here. Accordingly, this court should disregard their arguments against the firefighters rule. Nevertheless, it is clear that this case falls squarely within the parameters of the firefighters rule. Wadler clearly held that the question of whether or not an officer is on duty or off duty is not dispositive because officers face risk when they are off duty as well as on duty. And here, plaintiffs have argued that Officer Enchitegui went outside to investigate in pursuit of his duties as a police officer. They were very explicit about this in their pleadings as well as their arguments below. In addition, An investigation is a quintessential police function, and accordingly, the firefighters rule is plainly applicable. There is no difference in this case from the situation in Zangi v. Niagara Frontier Transportation Commission, where the Court of Appeals found that a person who was throwing snow where the Court of Appeals found that an officer was prevented from recovering for injuries that he encountered while approaching someone who is engaged in misconduct.
So,
and this court,
counsel, I have what may be a collateral question entirely off the radar, but what you're saying is that this officer would qualify for full benefits as if he were shot while on duty, because the firefighter's rule applies.
Your Honor,
He's
I don't.
treated the same way. You're telling us an off-duty officer who responds to the call of duty is treated in the same way as an officer who's on duty.
Under the firefighter's rule, Your Honor. However, I can't speak to how the question of benefits, what the proper standard is. But Wadler was very clear that whether or not an officer is on duty or off duty is not dispositive of whether or not the firefighter's rule applies. And here, the officer was clearly acting in pursuit of his police duties. He was wearing his shield, he was carrying his firearm, and plaintiffs themselves have argued and alleged that he was acting pursuant to his duties as a police officer. And they have not disputed until their reply on appeal that the firefighter's rule applies in this case. In addition, they failed to make out a claim under 205E. They have only alleged that on appeal that the New York State 911 Board requirements and the E911 call takers guide are predicates for liability. However, neither of these is satisfactory. First, the 911 Board's requirements do not set forth specific standards for 911 operators. They set forth standards for the facilities, for the technical requirements of an emergency answering point, for the training requirements. They do not set forth what a 911 operator should do. And plaintiffs have not identified a specific violation of any of those regulations. The E911 call takers guide is not a duly enacted body of law. In fact, it is very much like the NYPD patrol guide that the Court of Appeals found was not a sufficient predicate for liability under General Municipal Law, Section 205E. In that case, it was clear that the NYPD guide did not prescribe the specific action to be taken in every situation. And again, there is no evidence of any violation of a guideline set forth in the E911 call takers guide. It is pure speculation that the operator did not report Officer Enchategi's call to a supervisor. The record offers no substantiation of this speculation by plaintiffs. Although I think that these two bases, the firefighter's rule and the failure to identify a proper predicate of section for GML 205E are a sufficient reason to affirm, I also would just point out that there is no evidence with respect to a special duty that Officer Enchategi relied on anything the operator said. The evidence is clear. Officer Enchategi went to investigate of his own initiative. He was already outside.
This is Judge Gish. How do you respond to your adversary's claim that what he did in reliance to saying we'll get there as soon as possible is that he stayed? He could have safely retreated, but he stayed. Is that action in reliance, or can it, at least for the purposes of the case at this point, be considered so?
I would submit that, in fact, he did not stay in reliance on that statement, and the evidence and the record indicates that. The record indicates that because before the operator said to him, "Will you meet the police?" he indicated that he was outside wearing plain clothes and a black jacket. He was explaining how he could be identified. The operator, in response to that statement, said, "Oh, are you going to meet the police?" And he said yes. Then it was only at the end of the call after he'd already made the decision to wait to meet the police, that the operator said, assistance will be there as soon as possible. I'm sorry, Your Honor, I couldn't hear you.
Well, you didn't hear me because I didn't unmute my mic, that's why. But he could have met the police inside the building, as inside his home as well as outside. I mean, what he said doesn't necessitate where he was. And I know from the record in the criminal case that he was dressed entirely in black.
I understand, Your Honor. I do believe he was signaling to the operator how he could be identified so that he would not be mistaken for somebody else. And I think the record substantiates that. I also think there is.
I was going to say, how does that cut though? If he tells them, I'm going to meet somebody, it's with an expectation that somebody is going to come.
And somebody did come within 4 minutes of the phone call.
Well,
We are on a very.
issue. We're talking about reliance, though.
I understand,
if I
Your Honor.
say, you say you're coming, and I stay, and I tell you how to identify myself. That really, I mean, I don't see how that cuts into saying he'd stay there in any event. But
And he was dead by the time they got there.
I understand, Your Honor. However, as to the question of reliance, the only purported promise by the operator is assistance will be there as soon as possible. And
Right.
he had already decided to meet the police before the operator made that statement. The transcript is very clear.
Yeah, we
In fact,
understand.
the car that was dispatched pursuant to that 911 call didn't get there first. Another police car got there because they heard the bullets, they heard the shots.
Yes, Your Honor, that is correct.
Okay, let's hear a rebuttal from your adversary.
Thank you, Your Honors.
Thank you.
Thank you again, Your Honors. Just turning to the point I didn't get to before about the argument that 911 Operator's Guide isn't really rules, it's just a guide. The city has no case law about this. I find no case law on the Operator's Guide either. We see things about the patrol guide.
There's a lot of case law about guides and all sorts of things like that with the MTA, and you know the law on those.
What we don't have in this case, and what the city never produced, is anybody from 911 to say, these are really a guide. These aren't really mandatory duties. And even the city concedes in its brief, there are mandatory terms in the 911 call takers guide, and our own expert pointed out clear duties in procedures 105 and 106. They're all marked in his affidavit, and the procedures are in the record that required this to be made as a high priority call. And the police officers talked about how this would have been responded to differently. So that would be our response on the 911 call takers guide. I think we've covered the reliance issue there. If there are no more questions, we'll stand on our brief.
Thank you very much. Thank you both.
Thank you, Your Honor.
Thank you.
All right, Simon versus Frankinvest.
I will have enough time. Good afternoon, Your Honors. I'm William Siegel. I represent two of the numerous named defendants in this lawsuit, namely George Kessler and Lynn Rosenberg.
Right.
May it please the court. Your Honors, thank you for the opportunity to address you. Besides this appeal, there's another pending appeal by the plaintiff appellant against my two clients, Kessler and Rosenberg. The other appeal is case number 2020-01655 and is non-enumerated. So I will confine my oral argument only to this appeal. Although both
Right,
of the,
but it's on the calendar for today too, correct? Right.
although both of the plaintiffs' appeals seek the very same object, which is to overturn the decision of the lower court, which found for my clients and dismissed the plaintiff's suit against them. Quite frankly, neither of my clients belong in this case. And as a matter of fact, Lynn Rosenberg was an afterthought. She wasn't even named as a defendant in the original complaint. Unfortunately for my clients, they are caught up in the middle of a bitter family dispute between two brothers, the plaintiff, Pascal Simon, and the defendant, Francois Simon, who hate each other. The plaintiff's suit against my clients just consists of fabricated claims and deliberate misrepresentation of facts. As starters, the appellant's appeal brief introduces and relies upon an entirely new, never before presented cause of action, which shows up for the first time against Kessler, who is an attorney duly admitted to practice in New York, and that he has breached a financial duty, a fiduciary duty, excuse me. No such cause of action exists in any of the 4 prior verified complaints against Kessler. When Kessler,
And this is the 18th cause of action? What number?
I'm really not certain. There have been so many, Your Honor, that I'll stand on my brief.
Okay.
When Kessler, in the respondent's brief, pointed out that the appellant was incredulously attempting to appeal from a non-existing lower court decision that never entertained or ruled on the issue of his having breached the fiduciary duty, the appellant, in lieu of responding to such charges, instead launched into a barrage of new and different claims in his reply brief against Kessler, which had nothing or little to do with the particulars set forth in the appellant's and/or the respondent's appeal brief. This contravenes the purpose and underlying rationale of a reply brief, and the said previously unstated or disclosed allegations appearing in the reply brief should be entirely disregarded by this court. On point, pursuant to a similar fact pattern in the case of Turner versus Canale, 15 Appellate Division 3rd, 960, it's a 4th Department case in 2005, the court held, and I quote, "We note, in addition, that contentions raised for the first time in plaintiff's reply brief are not properly before the court," unquote.
So can you at least tell us what was dismissed against your client? What claims? I know everything, but what claims were against them that were dismissed?
Well, the fraud claim was dismissed. The waste claim was dismissed.
But they weren't the same claims against Kessler and Rosenberg, right?
Right.
Okay.
Moreover, the extraneous reply allegations are essentially time-barred and refer to events which occurred many, many years ago. And naturally, the respondents could not have responded to nor refute the newly hatched allegations of the reply brief through opposing papers. Simply put, the allegations in the appellant's appeal briefs have little or no bearing on the fraud case of cause of action, which is the basis of the plaintiff's suit against Mr. Kessler. The appellant merely suggests that because fraud charges were overturned against another defendant, his brother, Francois Simon, in a separate appeal, which Kessler was not a party to, that the fraud charges against Mr. Kessler should be revived. The glaring failure on the part of the plaintiff appellant is that nowhere in the 4 prior verified complaints has plaintiff established any association or connection of what one of the other defendants may have allegedly done to prove any complicity of fraud on the part of Mr. Kessler. Mr. Kessler's sole role was that of a lawyer, representing clients in their regular business endeavors, and he was not even the lawyer who prepared the JJS lease agreement, which the plaintiff complains of. As regards Ms. Rosenberg, the appellant bases his attempt to overrule the lower court's findings on the same regurgitated facts that she was a director of the defendant New York corporations. Clearly, she was not, and the appellant tries to mislead and confuse the court by bringing up references to Ms. Rosenberg being a director of the French foreign corporation, France Invest, and other Florida corporations.
But she was a director of the French corporation, right?
Yes, she was.
She owned 1 share or something like that.
She owned 1 share as an accommodation to apply with a since abrogated French law.
Well, whatever the reason, she owned it. I know there's some allegation that she needed to because of French law. That the family needed to have her, or not her, but somebody own it.
That is correct, and that was valued at 72 euros, which she returned that share as soon as the law changed, requiring 7 shareholders in this French corporation. So her connections to the other corporations simply does not make her a defendant of the New York corporations.
And when she became a director of Frankenvest, though, she issued a power of attorney in favor of Francoise to act on her behalf for the corporation, correct?
She did not. No, she didn't.
Did not?
The mother of the plaintiff, Francine, issued a power of attorney. Lynn Rosenberg never issued a power.
Never did.
Again, this could be caused by a lot of confusion of the facts just thrown in by the plaintiff. So our contention is Rosenberg was the secretary officer only of the New York defendant corporations, and she performed the normal duties associated with that corporation as enunciated in the corporate bylaws, basically to appear at the shareholders' meetings, to see that a quorum was present, to take notes and prepare reports. Her duties had nothing to do with policymaking decisions of the New York corporations. So what does the appellant choose to hang his hat on to prove otherwise? Well, he misleadingly refers the court to various citations in his reply brief to support his unfounded false claims. For example, claiming on pages 17 and 23, citing EF number 615, and on page 5, citing JR number 366, as examples of my client being a director of JJS, when the references are clearly unrelated to a position as a director. Simply, unambiguously, neither Kessler nor Rosenberg were ever directors of any of the New York corporations. Further, Ms. Rosenberg clearly established she was not even a party to the leasing resolution of JJS, which took place at a board meeting which was conducted in France, and which proof was not disputed by the appellant in the original motion to dismiss. Excuse me.
Believe it or not, sir, your time has run out, so I'm going to ask you to wrap this up.
I'm almost done. I thank you. All right. The lower court accordingly ruled that Ms. Rosenberg, under the circumstances, cannot be held for waste or breach of fiduciary duty, and dismissed the appellant's case against her. As to some of the allegations now appearing in the reply brief against Mr. Kessler, they are similarly without merit. Mr. Kessler did not prepare the JJS lease agreement. It was handled by another law firm, to wit, Nixon Peabody. The appellant is knowingly misleading the court, suggesting that my client, Mr. Kessler, prepared that agreement. Also, my clients complied with all the discovery demands of the appellant, and no objection to my client's answers were ever raised by motion or otherwise. Clearly, the appellant's desperate attempt to keep this action alive against my clients is an abuse of the court system. The appellant has wrongly sued 10 different defendants, and a strong deterrent in the form of substantial sanctions should be imposed against the appellant as a warning for her to continue this continued action. With that, I rest my case, Your Honor. I thank you for your time and attention.
All right. Anybody have any questions? Okay. Thank you very much.
Thank you. Have a good afternoon.
You too. All right. This session of the Appellate Division is now concluded. Thank you all.